solemnly swear or affirm the testimony you shall give to the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Go ahead.
Mr. Sheffield, your witness.
Thank you. Good afternoon, officer.
Good afternoon.
Can you please tell me your name?
Robert Mydell.
How do you spell your last name?
Mydell.
Okay. I want to take you back to December 1st of 2017 in an incident at Walmart shopping mall and your memory about that incident, okay?
Okay.
Are you familiar with your role in, or do you recall your role in investigating a shoplifting that involved Mr. Ahmaud Arbery and some other juveniles?
I do.
Okay.
Did you say 2018 or 13?
I said 2017, Your Honor.
17.
Yes. I want to ask you about that, the observations that you made that day and your interactions with Mr. Arbery in particular, okay?
Okay.
All right. How was it that you were alerted to come out to Walmart?
We were advised by dispatch at 14:53 hours or 2:53 p.m. about shoplifting that had occurred at Walmart at 150 Altam Connector, and there were 4 black males who were confronted by the loss prevention officer who were trying to leave the scene as I was arriving.
And what did you understand the nature of the confrontation was?
That the suspect in question was trying to take out a Vizio 65-inch TV through the grocery side doors.
And by suspect in question, do you mean Mr. Arbery?
Yes.
Okay. What did the officers there, the loss prevention officers there, tell you that they observed him do?
That he had the Vizio TV in a shopping cart trying to wheel it out of the grocery side doors, but they stopped him as he was going out the main exit.
Do you know what they said to him?
I'm not entirely sure what they said.
All right. And what about what he may have said to them?
I'm not sure.
All right. When did you meet up with Mr. Arbery?
I arrived in the parking lot from the Alabama Connector side, and I saw the 4 individuals in question walking through the parking lot, and I cut them off before they could get to Alabama Connector.
Were they still in the presence of the person that had stopped them at the door?
He was following behind them, yes.
Okay. How far behind him was he when he was following them?
No more than like 30 feet.
Do you know if he was asking them to stop or whether he was trying to engage them to stop and wait for law enforcement to arrive?
I'm not sure about the conversation that he may have had as I was arriving.
What did you see when you arrived?
Just the 4 males that the loss prevention officer was following that just walked through the parking lot.
Okay, and did you approach Mr. Arbery?
I approached all 4 individuals at the same time.
While they were walking?
That's correct.
Okay, and what happened next?
It was only me at the time, and there was 4 of them, and for just my safety and just to make sure that no one tried to run away while I was still investigating, I had them all sit on the ground until I had backup officers arrive.
Okay. Have you gone back through and looked at, did you have body cam that day?
I did.
Have you gone back and looked at your body cam video from that day?
I did.
You reviewed it before your testimony today?
Yes.
Okay. Do you remember whether or not when you asked those individuals, in particular Mr. Arbery, to stop walking, if Mr. Arbery stopped walking up on your command?
They did, and he did. However, Mr. Arbery was the only one who was vocal about it.
Okay, what do you mean by vocal?
He was a little confrontational. At first, he didn't want to do it. He didn't want to comply with sitting down. But after repeated requests, I'm not sure how many times I told him to sit down, they finally just did it. And I guess that was also when backup officers started to arrive.
Okay. Did you find anything unusual about your needing to tell Mr. Arbery in particular several times to obey the command that you were giving him?
Not necessarily, man.
Okay, why not?
It's, just you tell someone to do something and, they don't want to do it. It's kind of just, you ask them again and again until you do. Unfortunately, it's just kind of what we deal with.
What about the other males that were with him? Did they immediately comply and sit down?
Yes.
Okay. When you say confrontational and was saying things, what types of things was he saying?
To the context of specifics, I'm not entirely sure, but it was just, you could tell he was in an agitated state, the use of profane language, and just not wanting to comply.
And when you say agitated state, can you describe what it was that you observed that made you feel like Mr. Arbery was agitated?
Like I said, the use of profane language, the elevated tone of his voice, and it was the difference between him and the other three individuals who were complying that just kind of, I just knew that, if something were to happen, that it may have just been him and not the other three.
Was there anything about his body language?
Just the use. I'm not entirely sure. I mean, I could just tell like the stance that he was taking and how he was, the use of his hands, how he was moving them around and in rapid succession, just kind of made me seem as though that he was a little bit more on edge than the other three.
Okay. Did you confront him about the accusation that he had stolen a television?
Yes, he claimed that he did try and take it.
Was the other officer present there with you, talking to you about what not the other officer, but the store manager or the store personnel?
Yes, I'm sorry, go ahead.
Was that person present explaining to you in front of Mr. Arbery what he had observed Mr. Arbery do?
Yes.
Essentially confronting with Mr. Arbery that there was eyewitness accounts of his conduct.
That's correct.
And did he maintain that he had done nothing wrong?
At the time, yes.
Did you find anything unusual about that?
No.
Okay. Did you ultimately place Mr. Arbery under arrest for theft by shoplifting?
I did.
And do you know whether or not he was ultimately convicted of that offense?
Yes.
He was convicted for felony shoplifting?
That's correct.
Okay. I have noted on this board, did you help me create this board?
No.
I've noted here that there's a photograph here and it says arrest felony theft near the end of 2017. Is that accurate in terms of the
That's
timeline
correct.
that I have here?
That's correct.
Okay. On that particular day, do you recall what he was wearing?
He was wearing a black jacket with fur around the hood, no shirt underneath it, shorts and tennis shoes.
Okay. What was the weather like that day?
If I recall, it was sunny.
Okay, what that temperature, was it hot or cold? It's December, so was it cold on that day or was it hot? Do you recall?
Well, it's December in southeast Georgia. It was actually probably a little warmer than usual.
Did you find anything unusual or odd about the fact that, how would you classify this jacket? Was it a summer lightweight jacket or was it a winter coat? Use your own words.
I would describe it as a winter coat. It was big, it was fluffy, but because he wasn't wearing an undershirt and the jacket was open, I didn't really think too much into it.
Okay. 1 second, please. Do you recall, you said you had testified that he had entered a plea. Would that be a plea to felony theft or attempted theft?
I'm not entirely
Okay.
sure.
Do you know what he was convicted for? Whether it was a felony or a misdemeanor?
No, I'm not sure.
Or how much time he got on that particular offense?
I'm not sure.
Okay. Do you have documents with you that would reflect that to help you in your memory?
Documents reflecting.
Yeah, how the incident was resolved in the court system that didn't necessitate you coming to court to testify.
No, I don't have those documents.
Okay. 1 second, Your Honor. Nothing from you, Your Honor.
Just a second.
Thank you, Judge. Mr. Mindell, was this incident anything extraordinary or outside of the ordinary with any of the shopliftings you've ever encountered?
No.
No. And how were you dressed when you arrived?
I was in a Class B uniform, which consists of a short sleeve shirt that has our full markings, our badge, our patches, and then uniform pants and a duty belt.
Okay. It was obvious to anyone that you were, in fact, a law enforcement officer.
That's correct.
And when you arrived, what kind of vehicle did you arrive in?
And a marked vehicle.
Right. Now, do you recall that the other people who were with Mr. Arbery, 2 of them were 15 and 1 was 17?
That's correct.
Okay, so they were juveniles.
Yes.
And these are the 3 who sat down right away?
That's correct.
Okay. Now, he used profanity. Was this the first time you've heard someone use profanity with you?
No, ma'am.
Was this the first time someone has appeared to be agitated and using their hands to talk to you?
No, ma'am.
At any point in time, did you pull out your firearm on Mr. Arbery?
No, ma'am.
Is it unusual to have to repeat your commands to people?
No, it's not.
And the loss prevention officer, he personally saw Mr. Arbery attempting to wheel out the TV. Is that right?
That's correct.
And he reported that directly to you?
That's correct.
All right. Now, you placed Mr. Arbery under arrest.
Yes, ma'am.
What did you say to him when you placed him under arrest?
That he was being placed under arrest, and I read him his Miranda rights.
All right, so you actually said the words, "You're under arrest."
That's correct.
Is that how people know they've been placed under arrest?
Yes, ma'am.
And at no time did he run from you?
No.
Did he offer you violence at any point in time?
No.
I'll pass the witness. Thank you, Judge.
Any redirect?
Nothing further, Your Honor. Thank you. Witness may be excused.
Thank you. You may step down, Your Honor.
Thank you.
Defense calls Officer M. Canego.
Your Honor, while we're waiting for the next witness, I just want the record, I think the record's clear. We have joined in this motion, but we do not intend to ask any questions or recall any witnesses, or otherwise you don't need to ask if we have questions, but I just want to make it clear we are joining in the motion.
Just to make it clear to go, the motion itself was signed off by Mr. Sheffield and Mr. Rubin, and both defense counsel for Gregory McMichael. I assume Mr. Sheffield is speaking for all on this?
I'm speaking for the Michaels, Travis and Greg McMichael, and I understand that counsel for Mr. Bryant wants to join in that written motion and has now said he's not going to ask questions, but I've not been in communication with him about the questions that I'm asking today and all that, so I think that'll be up to him to decide if he wants to ask questions or not.
It is absolutely right.
Yeah.
We have no idea what he's presenting today, but we did file a written motion to adopt, and this motion was indicated by name, by number. I'm just saying that I don't have, the court doesn't need to ask me if I have any questions or witnesses, but I just wanted that to be clear.
Understood. Okay, let's go to the witness.
Do you solemnly swear or affirm the testimony you shall give to the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon, sir.
Good afternoon.
If you'll please give us your full name and spell your full name.
It's Michael Canego, Michael Kanago.
Very good. I want to direct your attention back to November 7th, 2017, when you had some involvement with Mr. Arbery, okay?
Okay.
Have you spoken to me about that incident with Mr. Arbery?
I have.
And in preparation for your testimony today, do you recall that you had a body cam video operating during that encounter?
I did.
Okay. Have you reviewed your body cam video about that encounter on that day?
Yes.
Okay. Can you tell us where you were employed back on November 7th, 2017?
The Glenn County Police Department as a patrol officer.
What were your responsibilities on patrol at that time?
Responsibilities would be respond to calls of service, enforce traffic, search for any kind of criminal activity, things of that nature.
Okay. And when you say search for criminal activity, what does that mean?
Look for different circumstances that may indicate that a crime has been committed or may be committed.
Okay. In this particular area of this stop, where was that? What was the area called?
It was Townsend Park,
Okay.
which is in the Arco neighborhood.
Townsend Park?
I'm not sure if that's the exact name, but it's on Townsend and Whitlock.
Okay. How long had you been patrolling and working as an officer in that area?
In that area, I'd be put into different zones, but I have patrolled that area before, and I've been a police officer at that point for I think about 6 months.
Okay. As part of your training, did you learn how to
I'm sorry, it was actually a year and a half I was a police officer. I had to do some
That's
mathematics. I
okay. Yeah,
apologize.
so November 2017. So you started back in 2015 at some point, or 2016? Okay. As part of your training, had you had any type of training about how to communicate with people in the community while you're investigating crimes that they could be involved with?
Yes.
Tell me a little bit about your communication training and background.
I was, part of my communication training was when I was in grad school at Florida State University. I was a graduate teacher's assistant where I actually taught fundamentals of speech in a lab. I graduated from Florida State University in 2015 with a degree in integrated marketing communication management. And just self-study when it came to communication.
What about in your training as a law enforcement officer? Were you taught how to approach people, to begin an investigation, and how to engage them in conversation?
I can't remember if we were ever fully trained on how to just approach people.
Okay. Tell me about what did you know in November of 2017 about the Townsend Park, Arco neighborhood area?
The Arco neighborhood, it's a fairly high crime rate area. We get quite a lot of drugs in that area. There's quite a bit of gang activity, everything from property crimes to crimes against people, vice crimes.
And how did you come to learn this?
Through my knowledge and from other officers who have worked that area.
Had you handled any calls prior to November 7, 2017, where you had gone out and done investigation yourself about these types of crimes in the Arco neighborhood?
Yes.
And is it correct to say that the Townsend Park is within the Arco neighborhood?
Yes.
Okay. On this particular day, what led to you stopping and speaking with Mr. Arbery?
When I was driving that area, patrolling the area, I saw this vehicle that was parked. I don't know the exact, the proxemics of it, but it was pretty far back next to the railroad tracks. And we don't usually, at least I have never seen a car parked in that area way back in the park. There's a gravel U-turn area that's in the front of the park. But I've never really seen people park way back in the grass.
So is there a road that runs in front of the park?
Yes, that would be Townsend Street.
Okay. And then you said there's a gravel parking lot, is that what you enter off of Townsend Street?
Yes.
Can you see what I'm writing up there?
No.
No?
Unless it's, no, I don't.
A little bit of a turn? Can you still see? Can you see this a little bit now?
Yes.
Maybe you can slide your chair over a little bit that way.
That's,
Nope, it's
it's
fastened.
done.
All right. You said there's a gravel area. Would it be fair to draw the gravel area around here?
Yes,
Okay. Are there restrooms here?
there are.
Where are those located?
Pretty much right behind the gravel.
Let's say this is the back of the park.
Mm-hmm.
Where would the restrooms be here?
If it's not to scale, but it's gonna be about, probably about 2 inches behind from there.
Okay,
That's probably where I
over
put
here?
them.
Okay. And there are train tracks that run next to this park?
Yes,
Where are they? Over here on the left side?
on the left side.
Okay. Is this fairly, not to scale, but kind of give us
Right.
some context? What is on the left side of the train tracks?
I think that is, I'm trying to think of the street, it's,
Is it a neighborhood?
there's 7, yeah, it's a neighborhood.
Okay, so there's houses here?
Yes.
Okay. And what about on this side of the neighborhood?
That, I think, is, if I'm not mistaken, it's Marley Avenue, which would be houses on that side as well.
Running this way?
Yes.
And then houses over here? Okay. So where then, in the context of this, was Mr. Arbery's car?
I would say somewhere in between the restrooms and the back, next to a, close to where the bigger power pole is.
Okay.
So right around where
Not all the way in the back?
Not all the way in the back,
But
right
this-
around, probably right around there.
Okay. Is there a road or gravel that leads back to this part of the park?
No.
Do people play in this area in the park?
I think they do now, since they've added a basketball court and some things toward the front.
Back in 2007?
But back in 2017, I don't think there was anything back there.
Okay. So this is, are you saying that you observed his car parked back there as you were driving past?
Yes.
When you observed his car, could you see who was in the car?
No.
Could you see the color of the person in the car?
No.
Why is it that you decided that you were going to go and see what that car was doing back there?
It was strange to see cars parked that far back, and just given that this neighborhood is known for specific crimes involving drugs, specific crimes, I just wanted to make sure that everything inside that vehicle was within the boundaries of the law.
Okay. At this point, as an officer who wants to investigate this, what did you decide that you were going to do and by heading back there?
I was going to check the registration of the vehicle, make sure the vehicle wasn't stolen. Was going to see if I can make contact with the occupant, make sure that he doesn't have any warrants, he or she, whoever that person would have been, doesn't have any warrants, make sure they have a valid license, things like that.
Were you interested in investigating whether or not there was drug activity? You had mentioned drug activity. Were you going to investigate whether there was any evidence of drug activity?
Yes.
Were you going to investigate whether there was any evidence of gang activity
Yes.
or an ongoing or potentially people or property type of a crime?
Yes.
Had you determined by the time you started to drive back that way that this was going to be the course of your investigation?
I determined that I was going to try to investigate what was going on back there, make sure that there was no crime being committed.
Okay. I want to show you the video, and at this time, Your Honor, I've marked as defense exhibit I think it's 28. Can we double check? Pre-marked all these for court in the state. Defense Exhibit 21. I'm going to show you, Officer, this. Can you see the screen over here?
I can't, if I can,
Can you
is it, can I
stand
stand up? Yeah.
Yes, is that okay, John?
Thank you.
Does that appear to be your body cam video from November 7, 2017?
Yes.
Okay. And after reviewing it before your testimony today, is that a fair and accurate depiction of what happened with your encounter with Mr. Arbery that day?
Yes.
Okay. Right. This time I'd like you to have a seat. Well, you need to go see it. There's not a monitor for the witness, Your Honor, is that what I understand?
Yeah, that's the case. So.
Can we have the leads on?
That's a live mic, I believe, right? Yes. Why don't we have it set down to that live mic? Should be able to see the video from there.
It is live, Your Honor.
Okay, they just need to.
Why don't you come sit over here in the jury box? I would like to ask you to talk with us about the observations that you're making, why you did what you're doing, and how you interpreted Mr. Arbery's conduct and behavior on that day.
I'm going to object to that. What happened on this video. His interpretation and what it meant to him is totally irrelevant for the purpose of the 404B motion.
Actually, Your Honor, the reason that we feel this particular event is important under 404B is that it is an interaction between Mr. Arbery and this witness. And so the only way we can really get to the essence of how the interaction is relevant is have a little bit of context with the way that this interaction made this witness feel, what he tried to do to assess the situation, because it's going to, again, go to the way that Mr. Arbery behaves and what it says about his intent and motive under similar circumstances when being confronted about his conduct and behavior. So I don't expect it's going to be extensive, but we will play the video and I'll ask a few questions along the way.
Once again, relevancy as to this officer, who is not those three defendants, and what his interpretation, what he's thinking, and how Mr. Arbery appears to him under these circumstances in 2017 have absolutely nothing to do with what took place in 2020.
So, what I'm hearing is twofold. One is the the objection to the admission of the evidence itself, which is still before the court. We're going to move to that. As to what I understood the request was by counsel was to have the witness explain conduct. Now, the way you asked the question made it sound like he was going to be explaining Mr. Arbery's conduct in the video. I won't allow it that way, but the witness can explain what he was doing and why.
Right.
But to the extent that he is speculating about
Correct.
whatever the Mr. Arbery was thinking at the
Correct.
time, that's not coming in.
Absolutely, and we are not admitting it for that, not seeking to admit it for that point, for this witness to speculate.
All right, go ahead.
Okay, great. Is it admitted, Your Honor?
Yes. You wouldn't intend
I move to admit Defense Exhibit 21.
No objection.
what format is it coming in on?
It has been saved on a flash drive as a video, and its label is Defense Exhibit 21.11.7.2017. So you will have it on that flash drive, and the clerk will have it on that flash drive. The court, I expect, would say it's admitted. Anything that's on that flash drive that is not admitted or can be considered by the court, we would delete it off there. And then the court would just have the exhibits that were admitted on the flash drive.
Okay, so we're talking about how it will be, it's been tendered, it's admitted. As far as physically getting into the record, what I'm saying is we will wait until the end of this hearing. And whatever flash drive is submitted to the clerk will only have what has been tendered and admitted, or tendered and not admitted to them. Nothing that has, what?
That's correct.
Okay. All right, we're clear?
Thank you.
What are you doing here?
Right here, I'm making my approach to Mr. Arbery's vehicle.
There's a pole that's just passed. Is that the pole that you were talking about in the tower?
I believe so.
And we don't have volume.
What is it?
Okay.
Ahmaud?
What is the first thing that you, when is the first time that you actually see the occupant of the car?
When he got out of the vehicle.
Okay. Did he get out of the vehicle? When did he get out of the vehicle?
Your Honor, at this time, the state's going to object. If we could just, the state would prefer that we just play the evidence and show it without the interruption of constant questions, and if he wants to ask questions afterwards, the state would just prefer that this evidence be tendered as opposed to parsed out with constant stopping and starting.
Well, I'd like to be able to specifically make the points to the court. If you'd like me to play all of it, and then I can go back and do it again.
My understanding was it was going to be limited. We're not going to go in 10-second increments through with it. We're just
Just to explain this
for the
witness.
officer to explain what he was doing on the video.
Correct. And I was just asking him what he was doing right there at that moment. Yes, sir. Okay.
What you doing out here, man? What's up? Bill?
Why did you ask him what he's doing out there?
Just a way to make contact with him.
Okay.
Find out, if I can find out what he was doing, just to get a baseline what he wanted to do, or what he was doing out in the park.
All right.
Court today?
Just rapping in the ball.
Gotcha. You got an ID on you, man?
Why did you ask him for his ID?
As for his ID, just to make sure that he didn't have any warrants, to make sure that he's not involved in any ongoing criminal investigation.
You mentioned that you had decided before you even drove all the way down there that you were going to do an investigation. Is this part of that investigation?
Yes.
I see that you're moving over now to the right side of this car, to the front passenger side. Why are you doing that?
We do that to gain a tactical advantage, to make sure that they're not, somebody isn't trying to grab a weapon, hide evidence, just to keep an eye on the person's hands.
Did you have any information about Mr. Arbery that he had a weapon at that point?
No.
So why are you doing it in this situation?
I do that in just about all my situations, just to make sure that somebody does not come out with a firearm.
Okay.
All right, thanks, man. Grab it with you, okay?
At this point, is there anything unusual to you about this encounter?
The only thing unusual at this point was just how far back it was parked.
Okay. What are you doing now?
Now I'm running his information through GCIC and CIC through our service channel. That's our dispatch operator that tells us if the person in question has warrants or we run the registration of the vehicle, make sure it's not stolen, make sure that it has insurance, registration is active, make sure he has a valid license.
And again, is this part of the initial investigation that you had sought out to do?
Yes.
185 dispatch, I'll be on service. 185 service. Get a 2728 through Georgia, please. It's going to be 058-065-478, 058-065-478. 10-4, 1063. Papa Quebec Zulu 4442, PQZ 4442.
Are you referring to the 10 codes?
Yes.
That's just, it just makes it easier to communicate. Sometimes words can get lost during transmission, so you just have it in a uniform 10 code that we all abide by. It's easier to communicate.
Did you learn anything about Mr. Arbery's license or his vehicle?
I learned that his license had been suspended. His vehicle, I believe, was active and valid when it comes to insurance registration.
Okay. What is that noise?
That loud beep is an intermittent beep that the body cam produces just to let us know that it's recording.
Do you hear Mr. Arbery speaking to you?
I do.
And what is he asking you?
He has to get his ID back.
Yeah, give me a second, man.
Do you hear what he's asking you at this point?
Yes.
What is he asking you?
He's asking why I'm fucking with him, and nobody's driving the car. So why am I messing with him? Is what he's asking.
Okay. Is there anything unusual about that?
I believe it was usually on relatively what appeared to be routine stops like this. If everything's good to go, people are usually patient, and they'll have no problem with us with their running their IDs and things of that nature. They don't usually come out and just verbally speak to them. They don't usually speak to us in that manner.
Okay. Are you thinking, does this impact your investigation at all, in the way you're thinking about your investigation?
It does.
In what way?
It rose trying to explain this the right way.
Take your time.
When somebody verbally escalates in that matter, in that way, sometimes it raises our suspicion as to why they're so angry, what's going on. Sometimes it can lead us to think there might be something else going on.
Have you drawn any conclusions at that point that something was in fact going on, quote unquote?
No.
Why am I fucking with you? You want to know why I'm fucking with you?
Why do you say that?
Part of it is because it's a matter of kind of a communicative leveling. You can communicate with somebody by speaking to them the way they speak to you. The other part of it was a little bit surprising that somebody was speaking to us in that regard when it was such a routine stop at the beginning.
Okay. Did you have any training about the way that you're supposed to speak with people if they use curse words at you or begin to speak to you in a way that's not typical?
It's essentially mirroring. That's something that we learn about in communication practices. You can mirror through mirror verbally, non-verbally, speech patterns, things of that nature.
Keep your hand in your pocket.
I ain't got shit on me. What the fuck you fucking with me for?
Is there anything about him walking towards you in this way that is concerning?
Having your arms out to the side, one thing that we have seen before in things like modern media and just TV, and what we learn through everyday lives is sometimes that could be construed as challenging body language.
Do you consider the possibility that things may escalate in ways that could become dangerous? Is that at all in your thought process?
Yes,
Does this contribute to those types of thoughts in any way?
it does.
In what way?
Part of it is the verbal escalation, the body language that appears to be challenging, not having conducted a pat down at that point, know if there's any weapons on him.
Okay.
Tell you why I'm here, man.
Why?
I'll tell you why I'm
Why?
here. Because this area is known for drug activity.
Drug?
Why do you tell him that?
He asked me.
Okay. closing of the distance between the two of you, is there anything concerning about that?
Yes, we want to make sure that we try to keep people a little bit further apart just for a reactionary distance if somebody were to try to attack somebody.
In your mind, is there anything that is assaultive about this conduct or not?
When we're approached that quickly, it's seen as a threat. At least I saw it as a threat for me.
How did you choose to handle it?
Verbally telling him to back up, bring my hand up as a nonverbal cue to step back.
Okay.
Fuck you talking about?
You want back up?
Fucking shit. Bitch, you hit
Send me another unit, please. Send me another unit.
All right, so you're calling for another unit. Why?
Since he had approached me and closed the distance with that kind of speed, and also because he was verbally escalating and also non-verbally escalating through his body language, it's usually better to have more than one officer in case things do get physical.
Why don't you just say, you know what, forget this. I'm going to leave this fellow alone and move on?
Just because we were already in this investigation, I wanted to find out what he was so angry about and see if there was more to it. We don't really have much of a luxury of just letting it go.
Did you hear what he said to you about the name that he called you and that he was, I'm going to quote, bitch, I'm going to fuck you up? Did that register with you?
I didn't hear that until I watched the body cam footage a couple years later.
Okay. Seeing it now, is there anything about it that is concerning to you?
Yes,
What?
that's a verbal threat of violence.
Shit. Fuck you talking about? Oh, what?
Turn and put your hands in the car. Turn around, put your hands in the car.
What's up?
Turn around, put your hands in the car. I'm checking for weapons. I'm checking for weapons.
Why are you doing this? You said you're checking for weapons. Why are you doing that?
I'm checking him for weapons because he's already been verbally aggressive, physically aggressive, and given that this area is known for violent crime, I want to make sure that for the duration of the stop that there didn't have any weapons on him.
I'm not searching you. I'm checking you for weapons. All right, man? You don't have any warrants. I know, but you're coming up on me, making me kind of nervous. Okay?
You bothering me for nothing. I work at Blue Beacon, bro.
Where's Blue Beacon?
Blue Beacon is on exit 29, man.
Okay. Listen, man, I'm not here to ruin your day. I'm here to look for any kind of criminal activity. That's all I'm doing.
Criminal activity? I'm in a fucking park at work. The fuck is you talking about?
Why are you trying to explain your purpose here?
Communication is part of the key to de-escalation. So I'm trying to explain to him why I'm there to try to bring him back down to a level where we can communicate.
And is it working in your mind?
No.
Is there anything that then causes you to think something about this particular individual that is concerning or suspicious?
Just his overall demeanor, the way that he's been approaching, the way that he's been verbally assaultive, things like that.
Are you trying to figure out what that could be related to?
Yes.
And what are some of the possibilities in your mind at that time?
Some of the possibilities are he's trying to, this is just speculation at this point.
Well, but let me stop you there. Are you trying to make decisions about what to do next in your investigation?
Yes.
And so I'm asking you what you're thinking in your own mind about what could be happening with this particular individual.
What I'm thinking is maybe he could be on some kind of drug, given he's so verbally aggressive and physically aggressive.
Is mental illness, or that he could have some kind of emotional or mental problem, is that a consideration?
It is.
Have you dealt with those types of issues as an officer on the force?
Yes.
At that time, had you dealt with those kind of issues?
Yes.
I fucking work. Check my damn history. Go to my job.
Okay.
She called my job right now. I
How
gotta
do you
work.
call your job, man?
Shit, what the fuck you talking about? Shit. What?
What are you doing now?
Right now I'm trying to look into the vehicle under plain view, see if there's anything of concern in the
Why?
vehicle.
Why?
Just part of the investigation, to make sure there aren't going to be any other, make sure I can't see any drugs or guns or anything that could be concerning in plain view.
When you say it's part of your investigation, are you saying the one that you decided you were going to do when you pulled into the park in the first place?
Yes.
Okay.
I'm not going to your car. Bro, don't touch me, bro. You can't touch
Listen.
me, bro. Don't touch.
So what happened there in your estimation?
He approached me thinking I was going to go into his car, which I wasn't going to do. He approached me fast enough to the point where I actually had to physically push him away from me.
Okay. And what was the concern that you had at that moment?
The concern at that point was he was going to assault me.
Do you feel like his conduct was in fact assaultive already or not?
I think it was to a point, but at that point that was clear that it was an assaultive behavior. That one was.
It's my car. And don't touch me.
I'm not touching your car.
Don't touch
I'm looking
me.
inside of your car.
Don't touch me. You can't look inside my shit. Enough.
Yeah, I'm 10-4. Send me another unit.
What does that mean? I'm 10-4, send me the unit.
That means I'm okay, but send me another officer.
Why?
Because he's still escalating. I just wanted to have another officer there in case things were to become physical.
Touch me, bro. Straight up.
I'm not touching you. Okay? Just very angry. Listen, man. What are you doing out here? You just chilling?
Chilling, bro. I'm rapping in the
Okay.
car. Took instrumentals.
Okay. That's fine. I'm just trying to figure out what's going on here.
I word.
Why are you talking to him in this way now?
I'm just trying to de-escalate the situation, trying to bring him back down like I was before,
For what purpose?
just so I can have a discussion with him and continue my investigation without running the risk of any kind of physical altercations.
So at this point, the totality of your experience thus far with Mr. Arbery, how would you characterize that in terms of your other experiences when you conduct these types of investigations?
This one was abnormal from what I had when it came to these more routine, suspicious vehicle, suspicious person calls. It's much more assaultive than the ones I've been on.
In the past, when you've used these techniques to try to talk to someone or explain to someone, in the general sense or the majority, how have those individuals responded to the techniques that you're using here in this particular style?
Once I explain to somebody why I'm doing what I'm doing, it'll usually calm them down because now they have that answer.
The fact that this continued in this way for the time period that it has, did it lead you to draw any further conclusions or just the ones that you've been arriving at already?
Just the ones I've been arriving at already, the ones that continually built up that we've previously mentioned.
Okay.
I get that you're working.
What else you want from me?
I'm just trying to figure out what's going on out here, man.
Working, rapping, I rap.
Okay.
Damn, what the hell is you talking
I
about?
know you're just acting very. You're jumping around, getting a little bit nervous on me. I think I see some.
Let me ask you this. With his explanations to you and his answers to you, do you feel he's connecting with you about the explanations that you're giving him?
I feel like he was trying to explain what he was doing, rapping in the park, but at the same time I wasn't fully, it didn't dispel my suspicion all the way after hearing he's just rapping in the park.
You see in the video another officer's approaching.
Yes.
Okay. Did you ultimately arrest Mr. Arbery for anything?
No.
Did you conclude your investigation?
Yes.
How so?
I allowed him to go.
Okay. And you said that you heard that there was a suspended license.
Yes.
Did you charge him with suspended license?
No, because I didn't see him drive.
Okay. You said that you had experienced some assaultive conduct and some moves by him towards you. Did you charge him with any kind of misdemeanor assault or any kind of assault at all?
No,
Or any kind of obstruction?
I did not.
Okay. Why not?
At that point, I didn't even realize that a crime had been committed. I was still relatively new, and I wasn't fully aware that his behavior was construed as a crime at that point.
In terms of what you felt as it was assaulted, but you weren't linking it up to an actual crime?
Correct.
Okay.
The plastic and the thing over here.
Go ahead, bro. You can't go on my car.
You're not allowing me to search your car?
You can't go in my seat.
I'm not asking you. Just don't reach the car, man.
You can't ain't pockets.
So what's this all about?
Officer Haney arrived to assist me. He had not been made aware that I had him down for weapons, and we want to make sure that during the course of some kind of investigation, we don't have people go back into a vehicle, because that area is an unknown area. We're still not sure if there is a weapon in the car or any kind of firearm, any kind of thing that can be used to assault either us or somebody else. So we want to keep him from going back into his car.
You say this is Officer
Haney.
Haney. You said he wasn't aware that you'd already done a pat down for weapons.
Correct.
Why not?
I never broadcasted over radio, didn't tell him.
Everybody, down. Warning, down. Stay on the ground. Stay on the ground.
Therefore, whatever he did to fight Greg McMichael was just his response. It was self-defense by him. But the law says, no, we're going to look at that. We're going to ask what they reasonably believed, and if they had a reasonable belief for it, then we are now going to call that a citizen's arrest. And therefore, what the law says is, if there's a lawful citizen's arrest underway, the person being arrested may not resist that arrest. Now, I'm only briefly mentioning this to the court because the state keeps talking about this ultimate conflict. And so where Mr. Arbery does for the first time this very dramatic turn onto Travis McMichael, that's going to be the question for the jury. Is he now, under the law, under the analysis of the law, hindsight, is he now the primary aggressor? And when you're talking about that question, the primary aggressor, that is a term of art under the law. And primary aggressor means the jury has got to figure that out. The jury is now tasked with who was the primary aggressor here. Of course, the court's going to give the jury the law. And if there is evidence that tends to shed light on the answer to that question, 401 says very clearly, going under our relevance prong, evidence is deemed relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. We're not talking about the elements of the offense. We're talking about the circumstances. And even the jury charge on this issue, Your Honor, gets to the heart of elements or issues. Elements or issues. And the issue in this case is what happened, why did it happen, and what was everybody perceiving. So the mental illness, we believe, is 401 relevant because it gets to the ultimate point of conflict during this, what we contend is a citizen's arrest, and what we intend to prove at trial was a citizen's arrest. The last thing I'll say, Your Honor, is this encounter is not so short. This encounter began on Burford. And this encounter involved the McMichaels stopping their truck, talking to Ahmaud, asking him, who are you? What are you doing? Why are you here? Right after he walked into 220 Satilla, but then bolted out in a racing fashion. And to ask him that, and then what they observed, which we will be offering at trial, and what Travis McMichael was perceiving at that moment, that he was unaware of, but what he was perceiving happened in the space of 10, 15 seconds, and then Mr. Arbery runs back down Burford, away from where he just ran, towards 220. And Travis McMichael and Greg do not follow. They watch as he now begins to run up to a truck. They don't know Mr. Bryant. They have not been on the phone with him or tried to coordinate with him. They just see a truck pull out and Mr. Arbery run up to that truck and now try to make entry into the driver's side door of that truck. And now Travis is thinking, what in the world is going on? What is wrong with this gentleman? There's something odd about this. And when he drives around down Holmes, he passes Mr. Arbery on Holmes. Mr. Arbery running up, Mr. McMichael driving down. There's no guns at any moments here. There's just more saying, hey, we want to talk to you, will you please stop? And so this encounter is a lot longer than the last few seconds. As a matter of fact, by the time Mr. Arbery runs to the truck and we finally see this final confrontation, that is the third encounter that Mr. McMichael had with Mr. Arbery. And in that third encounter is the third time that he's telling him to stop. And now it's escalating because of what Travis is trying to put together about this behavior. So behavior is a part of this case. And what happens between Mr. McMichael and Mr. Arbery is a part of this case. And if this evidence, we believe, will answer why it happens, how it happened, and that it is linked to mental illness, then that makes the mental illness relevant. There's the McWilliams case, there's the Lindstrom case, which is an 11th Circuit case, where we talk about how do we and are we allowed to get into mental illness. Mental illness is not off the table. It is relevant if it is, because it can speak to what motivates the witness against the defendants or the victims against the defendant. The McWilliams case is interesting because it involves the way that intoxication, alcohol and cocaine, can affect the mind and the mental processes and behavior. So thought and behavior becomes relevant to answer the question of who could be the primary aggressor. Not that the defendant is aware of the mental illness. That is not the calling card for admissibility. It's the jury is trying to determine. The defendant has said, he attacked me, and I had to use self-defense against him. That is the defendant's defense. The jury is allowed to consider this other evidence, not known by the defendant, to resolve that question. Is the defendant correct about him being the primary aggressor? Because they are tasked with that decision. And so that's the relevance and that's the nature of this evidence. And I intend, through this proffer, to make it relevant to the court and to drive it all the way down to the point of causal connection to the acts on the 23rd. And I believe if I can do that, then the court would have the authority to allow it to come into evidence to aid in the jury's determination of those issues, making them more probable or less probable.
Anything from the state before the proffer?
Yes, Your Honor. The underlying premise is absolutely incorrect. What Mr. Sheffield just stated is not the law. He stated that the defendants had to have a reasonable belief that a crime had been committed. That is not the standard at all. If you're going to take the law into your own hands, you had better know what the law is. They chose to take the law into their own hands, and the citizen's arrest law is designed specifically for exigent circumstances of I am present when the felony happens, or I'm the eye in the sky and I watch it because I'm the person at Walmart seeing somebody steal it. It's in my immediate knowledge. And if it happens to be a felony, then I can give chase and try and make an arrest. But I can only arrest to a level that's reasonable. Their reasonable belief that on February 11th, Ahmaud Arbery was committing some crime, well, we know what crime they thought he was committing then, because Greg McMichael says he was committing criminal trespass, which is a misdemeanor. Their reasonable belief is irrelevant. So that takes us, once again, back to this issue of who's the primary aggressor. They're basically arguing Chandler at this point. And the Supreme Court has said Chandler is not relevant. The question is, who could be the primary aggressor? Well, the primary aggression took place when Greg McMichael said, there goes that guy running down the street, let's grab our guns and go after him and detain him. That's when the primary aggression took place. Travis McMichael in order to make any of this relevant, would have to testify. Mr. Sheffield just got up here and said Travis has to, think about what his perspective is about what's happening. Well, he'd have to take the stand and he'd have to tell the jury, this is what I perceived was going on during these periods of time. Otherwise, it's totally and completely irrelevant. And it's irrelevant anyways, because is Travis McMichael correct that Ahmaud Arbery is the primary aggressor? That is not the question here. Because the primary aggression took place absolutely 10 minutes before when this whole thing started. Travis McMichael is pointing a shotgun at Ahmaud Arbery. Ahmaud Arbery is the one in fear for his life. And to say that his mental illness could have caused this? I thought we all agreed it was offensive to say that Ahmaud Arbery's mental illness is the cause of his death. But that's what Mr. Sheffield just got up here and argued. And how do you prove it? How do you prove it at that time he was suffering under any sort of delusion or any sort of mental health stressor whatsoever based on a few hours in December of 2018? It's not relevant on any issue whatsoever, and it does not survive a 403 analysis. It is far more prejudicial than it is probative on any matter in this case whatsoever. The rules of evidence do not allow this. And despite the defense repeatedly saying the state is the one that provided this to them, somehow that allows them to get into HIPAA and to violate personal mental health status. The public policy angle of this is quite troubling, Your Honor. Basically telling America that they should not seek mental health because if someone else chooses to victimize you, your private, privileged conversations with your doctor are all of a sudden going to be on that witness stand for everyone to see. So everyone in America should be terrified right now if they're seeing a mental health professional because somebody's going to choose to victimize that person and that person's defense attorney is going to come and get their mental health records and go, see, it's really your fault. You have mental health issues. And that's really relevant to why my person gets to victimize you. And that's very offensive. So from a public policy point of view, it's not allowed. And the state's offended that we're trying to go down this road with this. And the rules of evidence certainly do not allow this. It is far more prejudicial than probative on any issue in this case, especially since it's the reasonable standard of the defendants and their behavior that day, not Ahmaud Arbery's. Thank you.
So there were a couple motions to quash here, but I understand they were withdrawn.
That's correct, Your Honor.
Yes, Judge. I don't know that if I need to respond or address some of the issues that the court brought up about citizens arrest, and I think these are all going to be issues that we need to present evidence on and about through the course of the trial. I'm not here at this moment to argue citizens arrest. We have to have a reasonable and probable ground of suspicion that something happened. The intrinsic evidence that the state agreed should be admitted, the dialogue of Larry English and the videos and all that was discussed with the McMichaels about the fact that thousands of dollars of equipment had been stolen and how they believe that it was Ahmaud Arbery that did that.
Objection. Your Honor, at this point in time, the reason the state's objecting is because that is a complete mischaracterization of the Larry English 911 call. And if Mr. Sheffield wishes to play that right now, the Larry English 911 call basically says the two white people from November 17th are the ones who he suspects stole all of his boat equipment. And so
Let's just start. I'd just like to get it in the proper.
Yes, sir, I would too. All right, may I do that?
Yes.
Okay. And Judge, forecasting this is another issue that is a very important, significant issue that I think it would be beneficial for us to brief it to the court, and perhaps we could maintain a similar schedule or the same schedule as the 404B, where we could submit this to Your Honor at the same time. Perhaps I won't speak for all counsel, but I'm going to be asking the court to allow us to submit law on this.
Well, let's get the proper and we'll figure out what we're going to
Okay,
do.
all right, great.
We call
Anderson.
Do you solemnly swear or affirm the testimony you shall give to the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon, Ms. Anderson. I'm Jason Sheffield.
Nice to meet you.
Nice to see you. I believe you and I have talked on the phone once or twice, yes? Okay. So one of our rules here in court is that we would prefer you to say yes or no when answering questions. The is a difficult translation for the court reporter.
Okay.
Great. Ms. Anderson, I want to speak with you about an evaluation that you did back in December of 2018 with Mr. Ahmaud Arbery, okay?
Okay.
Where were you working at that time?
Gateway.
And how long had you been working there?
Started in March of 2016.
And what was your title?
Registered nurse.
And how is it that you obtained your registered nursing license?
Attended college.
When did you go to college?
I graduated from College of Coastal Georgia in 2012.
And at that point, had you then had your RN license?
Yes, sir.
Okay. And did you have any kind of specialty that you focused on as a registered nurse?
The first 4 years was hematology and oncology. The next 4 years was mental health and substance abuse. And now I'm currently working at a nursing home as infection control.
Okay. So is it fair to say around 2016, that's when you began to focus on mental health?
Correct.
All right. And how is it that you made that transition to mental health?
I wanted to leave night shift, and I found a
Did
Monday
you
through
do
Friday
any,
job.
sorry?
I said, and I found a Monday through Friday job.
Did you do any additional study on mental health or take any kind of continuing education classes on mental health?
While working at Gateway, we did do Relias trainings, so that would keep us up to date.
All right. And so did you say that you started working at Gateway at 2016 when you made that transition? Is that a yes? Okay. So what kind of training? What is Relias training?
It's just an online course that you click through and you read, and then you take a little test at the end.
Okay. And what was your role at Gateway beginning in 2016?
The outpatient registered nurse.
Okay. And what were some of the duties that you had?
Providing nursing assessments, doing intakes, giving monthly injections, responding to medical emergencies.
Okay. At what point in time did you start to do mental evaluations of persons at Gateway?
I can't recall.
Okay. So by December of 2018, do you know how many mental evaluations you would have done up to that point?
I can't recall.
Okay, so the specific number you can't recall, can you group it into an amount? Is it 50 or less or 50 or more?
I don't know, because I don't recall at what point I started doing intakes.
Okay. Were you supervised by anybody when you did your evaluations?
Not
Any-
not necessarily.
Okay, so how is it that you would come up with a diagnosis?
I would put what I suspected the diagnosis was, and then they would follow up with either the doctor or the nurse practitioner, and they would have to verify that diagnosis.
Okay, and how is it that you would come to the point where you had an opinion about what the diagnosis was?
After spending a certain amount of time with them and asking them certain questions, it kind of leads you in one way or the other.
Okay, so when you say spending time asking certain questions, spending time with whom?
The clients.
Okay. And what is it that you would be accessing in terms of to help you through your interview and then make a decision what the diagnosis is? Would you reference any materials? Would you look anything up using any books or learned treaties? How did you get to the point where you could say, this is what I think the diagnosis is?
Because whenever I make diagnoses, I keep them very basic. So
Okay.
the nurse practitioner and the doctor can upgrade them to whatever they deem necessary.
All right. Let me specifically ask you about schizoaffective disorder. When is the first time that you learned about that disorder and what the signs or traits or features of that disorder are?
Probably 2017, end
Okay.
of 2016, beginning of 2017.
So after you began working at Gateway,
Correct.
did you see a lot of patients who you came to understand? Okay.
Sorry.
Need some water?
Sorry, my allergies.
You need some water?
I'm good.
Did you see a lot of patients that you came to understand had schizoaffective disorder?
There's quite a few.
Meaning, and then how is it that you came to be able to identify that somebody had, in fact, to your opinion, or the opinion of others, that they had schizoaffective disorder?
By some of the characteristics that they would list off.
Like what?
I can't recall. I haven't studied that in over a year.
Okay, so you're no longer doing this particular type of work?
No, I'm infection control now.
Okay, when did you move over to infection control?
March of last year.
Okay, that would be March of 2020. Yes?
Yes.
Okay. So for 2016 through 2000, that's where we get the 4 years.
Right.
Okay. In this case, can you describe to us back in 2018 what the process was, how somebody would come to you or to Gateway to be assessed for mental illness?
So they would have to come in through what is called open access. So basically you came in, you sign up, and you wait for the first available person to see you to do your assessment.
Okay. And what are your responsibilities then in doing the assessment? What do you do?
A behavioral health assessment. So you just read the questions off the assessment itself and just document their answers.
Okay. And once they give you their answers and once you get the information from them, what do you do next with that information?
As they're talking, I'm typing it into the computer.
Okay. And at what point do you reach a conclusion about what you think they may be suffering from or not?
At the end of the assessment.
Okay. And then do you give that assessment to another person?
No.
Is it reviewed by somebody else?
The nurse practitioner and the physician can review it.
And you said that. Okay. So,
Can I ask a question?
yes, Judge.
Did a nurse practitioner or a physician review this?
Yes, Judge.
Okay.
Yes.
So we're gonna,
I'll get right to it now, actually.
okay.
In this case,
Objection. While I appreciate Mr. Sheffield answering the court's question, I believe the witness may have had a separate answer.
Oh, I was just saying I didn't know. I don't have the documents. They're all put into the computer. And I no longer have access to it.
Thank you.
so I have here what's marked as Defense Exhibit 9. It's the Gateway records that's been provided to the state already. It has a certification on it that authenticates the document. We will provide initially, Judge, 4 pages of this, and I think that we may have gotten the rest, but it's been certified for purposes of authentication, and it's been provided to the state. Yes, hold on. Is the purpose of creating this record to aid you in making a diagnosis?
Yes, because you want to treat them for the appropriate diagnosis.
Okay, so the documents that you've talked about creating in the assessment that you're doing, are you asking the patient and getting them to tell you what's going on?
Correct.
Are you listening to the statements that they're making?
Correct.
And are you using those statements and the answers that they give you to then diagnose them with a medical or condition or not?
Correct.
Okay.
At the end of the assessment.
Okay. At this time, I move Defense Exhibit 9 into evidence.
No objection.
Is there medical records?
They are.
Actually, Your Honor, I believe, yes, we probably would need a protective order if we're going to go ahead and put these in.
To make sure I understand what the state is saying, a protective order so that these records don't go outside of the court and are sealed for purposes of being a part of the record?
I don't know what's in those records. I'm open to the proffer and argument. Now, how this is done is a great concern to me.
We will.
Because those are an individual's medical records, the decedent here. It's not clear who's speaking for whom and whether or not there's an objection. There was a motion to quash. I have to go back in and try
Yes,
to
Judge.
work through. I mean, there's private medical information, HIPAA without, I mean, I don't know what the status of the subpoenas were.
I can
There are
answer
a lot of questions I have about just tendering medical records in this case.
We're happy to try to work through it, Your Honor. There were motions to quash filed about 2 employees who worked on this case. I do not believe, but whatever the case is, that motion to quash was filed by Gateway representatives, attorneys, and they have withdrawn the motion to quash. I can state to the court that we have a DCS, Department of Community Supervision, video showing Mr. Arbery's release of this information to the state at the time that he was asked to do this mental evaluation. And so that release has been captured on video, but whatever the case is at this point, Your Honor, Gateway has withdrawn their motion to quash the subpoenas. The way I intend to use these records, Your Honor, the witness has said that she's having difficulty remembering some things. I do want to work through the records with her so that we can understand what she did, the diagnosis that she came to, and who was involved in that. We do intend to use these records with our next witness, but I think to the extent that the court can allow them to come into evidence, accept them into evidence, and then sign a protective order that all the parties agree to, that these will not be disseminated, and to my knowledge, they have not been disseminated anywhere.
Well, at this point, we just keep them under seal until the court's ruled on the motion, or ruled on the response or the motion limiting how you want to.
Sure. Now, will the court allow me to, I certainly want to talk about some of the information that's in here. I also have it to where I could put the documents up on the screen to show the court where it says what it says. But I think that if there's no motion to quash them, and if Mr. Arbery himself signed a release of these documents to the state, and the state has provided them to us, I would say that that issue, HIPAA, while HIPAA can survive death, it has been waived, and therefore the documents are now in issue, and that HIPAA has been complied with. The court also, just so that you know, the court has the authority to order that the records become part of the record if the court deems that they're relevant. And so that would take care of, for lack of a better word, the HIPAA issue.
Problems were proper. So they'd
Yeah,
be
but-
relevant to the proper.
Well, they're relevant to the, you're right, Judge. So if we don't have them at trial, we don't have them at trial. But I do need to make a record to the court and convince the court that certain things have happened in a proper way that led to a diagnosis that is now being considered in the totality of a much bigger picture with our next witness. So I would like to be able to talk about the contents of these records for the purpose of diagnosis. And then, once that's established, how that diagnosis and its very real effects, as we have seen over a timeline on Mr. Arbery, impact the relevant issue in this case.
May I ask a question?
Unfortunately not at this point. Just bear with us for just a
Can you
second.
take a break?
No, I was just, no,
Okay.
Is the question directed to the court?
I was just wondering how this would affect my nursing license.
Your Honor, I think I can assist with that on some level. So where the witness has been subpoenaed to court and where the court has authorized the witness to discuss the matter, that order by the court essentially would allow you to testify to, or allow the witness to testify to privileged information because the court has made a determination that the privilege needs to give way to the relevant issue before the court. And so the Bobo case in Georgia, the Lindstrom case in Georgia, those cases were about medical records and mental illness, and those became part of the record in that case. It's a lot like juvenile court records, other medical records, psychiatric records that touch on important issues.
So the records include the assessment and the diagnosis.
Most importantly, Your Honor, it includes the statements made by Mr. Arbery about the very real symptoms and problems that he was having. And because the challenge here is that it's what the person says that leads to the diagnosis, along with other behaviors observed, that we really don't have a foundation for the diagnosis without taking consideration what Ms. Anderson observed and what Mr. Arbery said.
Listen, I don't think the state's, I've heard the state challenge a diagnosis that exists. I mean, isn't the way to possibly avoid the issue in the records? I mean, there's a diagnosis. Explain to the court why that diagnosis would be relevant based upon this argument under 401. And at this point, as far as all of the statements associated with the diagnosis, if it's there, it's there. Well, you tell me why that diagnosis is relevant in Mr. Arbery's case.
Can I do it now? Or is that ultimately what you're going to be determining?
I'm trying to figure out how to avoid all these medical records coming in, statements of the defendants associated with the diagnosis. If there's no dispute that he has been diagnosed with this,
I would inquire of the state if they dispute that.
Then the question then simply becomes whether or not that diagnosis fits within your relevance argument, or whether we have this character evidence.
Yes, Your Honor. The state does not dispute that Gateway on December 14th of 2018 spent 2 hours from 8:30 in the morning to 10:30 in the morning doing this assessment, and that a registered nurse came up with a diagnosis at that time, and that another nurse, who I believe is not here, a Miss Ruby Pontello, then spent a half an hour with Mr. Arbery in the afternoon and then prescribed him medication. And that is the extent of this diagnosis. So while we don't dispute that this diagnosis took place, we are very concerned about the quality of the diagnosis. This was not ongoing treatment. It was a one-time situation. Mr. Arbery never returned, and there is nothing after December 14th of 2018. So while we don't dispute these records exist, we do dispute the quality of such a diagnosis, because what I believe the witness just testified to is she writes down the suspected diagnosis and then someone else then reviews it.
Well,
So
that would be my question, is if we didn't have that next step, then we wouldn't be having this conversation.
I can respond, Your Honor, if you'd like.
Yeah, I'm just thinking, sure. For the purposes of the court's analysis of this argument, all I really need to know is whether there was a diagnosis and then why that diagnosis would be relevant under the circumstances. As far as what Mr. Arbery said or did or anything else, I'm not sure I'm there yet. And if the state is under the circumstances, well, let's say in 2018, registered, or nurse practitioner, registered nurse.
Registered nurse, Your Honor,
Registered
followed
nurse.
by a nurse practitioner with the authority to make the ultimate diagnosis, yes.
Establish that diagnosis. Then what would be more important for me is then what that diagnosis means in 2020.
Right. May I also suggest, though, Your Honor, the characterization that the state, in the tonal characterization by the state of this sort of 2 hour plus 30 minutes, the state's not contending that it wasn't made. I think the real question, Your Honor, is it an accurate diagnosis or not? Is it a true, in fact, correct diagnosis or not? And I don't think the court could move forward, although this is one part of the narrative that we will be using with our forensic psychiatrist who will be testifying next to help put all this together. I do believe it's important for the court to have some information from this witness, in particular, the facts. Now, our next witness can come in and say, I've reviewed these records and I see what Mr. Arbery was saying on that day. And it's important to note that when he described what he was thinking or what he was feeling, that we have to listen very carefully what Mr. Arbery is saying, because he is at a point in time where he's honestly seeking to be diagnosed with problems that are ongoing in his life. The validity and the accuracy is critical. Now, we can do that with our next witness, but the next witness is going to be using, you can't diagnose somebody without observing them and asking them questions. This is the document that has those observations. It's the forms, it's the question answering as the witness testified. She typed in exactly what he said. That is necessary. We don't have a diagnosis without those. So I would like to make the court aware of what those things are. It sounds like the state may be contending that this was not a quality diagnosis. So to that extent, I would like to be able to rebut that. I may not do that with this.
We're just litigating. I mean, you're just litigating.
I'm trying to make a responsive argument about relevance and why the record should be admitted. These medical records are in fact admissible. HIPAA can be waived, can be waived, but it can also be the court rules that they come in. Now, ultimately, whether we post them up on the board or they get made part of the clerk's file and they get shown to a jury, we can make those arguments later. But I do think the court needs to have as much information as possible to assess that this is a correct diagnosis.
See, I think I can take a step back from that, and I think this matter can probably be bifurcated. I mean, the first question is whether or not we reach it. Honestly, the first question is I've got to make a determination whether or not on a basic character issue that this is the type of evidence that can come in a case like this. I'm not comfortable having made that decision. I've got to look at that.
Sure.
And then we start getting into, if the court does in fact determine that this is the type of evidence that could come in, as non-404B simply is relevant, then it's the quality of that evidence, right? So this is what you're talking about here. When I say you're litigating it, what I'm saying is we're now going to the quality of that evidence, and the state's going to challenge it, you're going to put it up, make a decision about the experts that made the diagnosis and what the statements were and whether or not it was good. That's something that I'm not sure we get to yet. I think that can be bifurcated, because I think the first question is the most important question, which is, do we even need to go down this road? And since I'm not comfortable with that yet, I'm inclined to wait on the full tender and work through the issue of just basic relevance at this point. That's what I'm looking at.
Okay, and so for the court to arrive at relevance, what I have begun to present to Your Honor about the way that mental illness impacts Mr. Arbery, and what I intend to show Your Honor, the timeline, the observations that people are making about his conduct and behavior, and that the mental illness explains that and how it leads to the conduct in this case that the jury has to determine. The mental illness aids in that. So if Your Honor would like for us to talk first about relevance, then I'd like some direction on how Your Honor would like to receive that. Because it sounds like you're saying you want us to talk about relevance first, maybe case law that deals with this issue and other matters, and then say, okay, I make a finding now, am I right?
Yeah. I mean, I'm tempted to almost stop where we are and hit the relevance issue, because, you know, I've got to be comfortable with that before we go down this road with these medical records. It will also give the court an opportunity to think through exactly what needs to come in, if in fact something is going to come in, and how that gets presented, because it would probably be hard to say this from where you're standing, but this would be a rather unique issue that the court needs to address, because, you know, you're making an argument, you're making a 404, you're saying you're not making a 404B argument, but basically what we've got is a 401 analysis, 403 analysis, and what can be proved. Well, that's basically 404B, right?
I disagree.
Well, that's the same analysis that's used in 404B.
It is, yes, Your Honor.
You're right, that's my point. So you're asking the court to jump through a bunch of hoops to get to where you want to go, despite the fact that, you know, you've got cases out there about Chandler no longer applying, the new rules of evidence, and now we're where we are. I got a lot of questions about this, because this to me is a rather unique way of approaching justification and self-defense, particularly when you start talking about the victim's state of mind at the time. So all that said, I'm going to stop where we are. Your co-counsel will stop you.
Okay, may I take a moment? We're thinking very similarly. So, Your Honor, I think in order for the court to make, let's set these records and let's put them away for a moment. The court is asking us to help it understand what is relevant about Mr. Arbery having schizoaffective disorder. That first basic, what is relevant about that? I think the way to make it relevant is to hear from our next witness, who will talk about his particular form of schizoaffective disorder based on the timeline of things that she has reviewed. Now, an expert witness can rely on a lot of things in coming to a conclusion. And part of the proffer to this court needs to be these things in evidence for the court to consider. And I say it because I believe that in order for me to truly demonstrate the relevance, I need the court to look at these things. So however we do that eventually, we'll work that out. But I think we need to have the opportunity to make it relevant through our forensic psychiatrist, who has a voluminous amount of evidence over the course of 3 years that she has looked at and has arrived at the conclusion not only was this diagnosis correct at the time in 2018, but that it continued to exist. Here we see proof of it, and now here's what this mental illness is really about and how it impacts Mr. Arbery. And I believe that that would seal the relevance issue for the court to make the determination. But the witness is going to have to talk about the incidences that we've seen some of today, as well as other evidence where people are stating things about his conduct and behavior that helps her reach the conclusion that he has it. So it could be one of two ways. It could be that the court allows the witness right now to fortify the diagnosis so that the court is convinced this is the proper diagnosis, and then allow the witness to say, these are the features and traits of this mental illness that are particular to Mr. Arbery, and we see through history how it causes Mr. Arbery to behave under certain circumstances. And I think that we would then have the relevance for February 23rd.
Is this a treating?
This is a treating forensic board certified psychiatrist that treats patients, that has been the head of the jail.
At any point did this individual actually treat?
No, it was not the treating physician.
Really a forensic review.
It's not only a forensic review, but it's the same kind of review that is court ordered time and time again with benefit to other people. This is not a cold analysis. As a matter of fact, the reason that I used this chart for the court And what the witness will say is that in this particular case, the documents used by Dr. Kelly Kaufman and the answers provided in the forms that were used by Gateway are the very things that she herself does to review the way that a client answers questions, and what they say is part of it. Now, she didn't interview Mr. Arbery herself, but that does not invalidate her review. And on top of reading the quotes of what Mr. Arbery was saying, she also has the benefit of seeing Mr. Arbery in various environments and the way that he is reacting under certain she has the benefit of observing his behavior over a 8-year period of time, as well as she has the benefit of listening to family members talk about Mr. Arbery. She has the benefit of the Department of Community Services making judgments and saying things about Mr. Arbery. And she has the benefit of her experience with other individuals who suffer from schizoaffective disorder that she has seen in the various clinical settings where she either ran the clinical setting and treated and diagnosed and treated and oversaw the diagnosis and treatment. So there's also, I'll make Your Honor aware, there's something called a forensic autopsy. And a forensic autopsy is used in many cases after the fact of death. It's admissible in court. In fact, it's often ordered by courts in civil cases where there are insurance litigation claims being made about what led to the death. And so a forensic, or I should say what I call it, the autopsy, I forgot the word I just used. Well, this post-mortem forensic assessment is something that is done in courts often to aid the court or aid the decision maker in how they assess and relate to the diagnosis. So I think that the only way to get it done, Judge, is to have her talk to the court about how it's relevant. That keeps the records out, but it would allow her to talk about the issues in the case.
Without referring, but how does it?
I've tried to state it, as simply as I can. I don't know if there's another way the court can engage me and if I've not clarified it, but I think that.
Well, I go back to what I said. First question is relevance. Whether or not, under these circumstances, this mental health diagnosis would be relevant to the court, or not relevant, would be admissible in the case. And I am trying to avoid getting into the specific medical records of Mr. Arbery. It sounds to me that that's exactly where you feel that the court has to go in order to make that decision. And what I'm working through is whether or not that's the case or not.
I understand. Would you want to take this evening to do a little more?
Yeah, let's move on to another issue. I'm going to think it through. If the court determined that it's relevant, then the records are going to be coming in. But if not, they are significant. And the moment they become a record in this case, if the court determines that they're not relevant, the way that this case has gone, they will be everywhere. They're part of the court's record, which means anybody can come in and look at the court's record. And I have a real problem with simply allowing that.
I agree.
And that's the problem I've got right now. So I'm trying to figure out if there's a different way to do this. So yeah, let's move on. We'll come back at it in the morning and figure out if there's a better way to do this than simply tendering in medical health records.
Okay. Your Honor, I apologize. I know you want to move on. If I may just address the court. The court is absolutely correct. the question here is, why would this diagnosis be relevant to any issue in this case? So that leads us back to what are the issues in this case? And the issues in this case are citizen's arrest and self-defense. Therefore, Mr. Ahmaud Arbery's mental health is not relevant on any issue at all in dispute in this case, because it sheds absolutely no light on any issue in this case. 401 is absolutely correct. I mean, it has to, any tendency to make the existence of any fact that is of consequence. How is his mental health? He could have been a Rhodes Scholar. He could have been plucking his arms like a chicken running down the street. His mental health is absolutely relevant to the reasonableness of their actions. And I agree with the court. I believe that we should go and assess the relevancy of this prior to going into the actual quality and quantity of these medical records.
That's good. We'll get into it tomorrow.
We'll get into it tomorrow.
Which means, ma'am, you can go ahead and sit down. You are now released. So there's a possibility she's recalled.
Of course, yes, sir. Thank you.
So
My
you-
apologies,
I need
Mr.
to be here
You
tomorrow.
need to be available tomorrow. Yes, ma'am.
Okay.
Thank you. Okay, so with that, Your Honor, and with the court's decision that we want to work through this evening and talk again tomorrow morning, I don't have the ability right now to respond. And so I'll wait and we'll talk again in the morning and go from there. Thank you.
Let's work through a couple issues that maybe we can work through a little bit more quickly and knock off this list. Mr. Bryan had filed his omnibus motion. I want to try to clean that up if I could, Mr. Goff.
Yes, sir.
There had been reference at the beginning of this hearing to this Jackson Denno issue. I understand we're going to take that up at some point in the future. There was also a motion that I assume is going to be joined, although I don't know, and this is what I'd like to bring up now, by the other parties about additional peremptory challenges. That is part of this omnibus motion. It's probably going to come up before the jury trial. I'm going to ask that the lawyers discuss it and how, in fact, peremptory challenges are going to be requested. I'm assuming it's going to be beyond the 9, and whether or not an agreement can be reached amongst counsel before trial is the court ruling on this motion itself. Okay, fair enough?
Fair enough.
Court's instruction?
Yes, Your Honor.
There was also this omnibus motion to adopt motions of co-defendants. I generally don't have a problem with that as long as I know what that means. So when I ask you specificity, if you haven't put on the record that you're adopting a particular motion, then it didn't happen. Okay?
Yes, Your Honor.
That's how I'm going to treat the record and how anybody looking at the record will understand the court's view. Okay? There was a reference to severance. I understand that's not before the court. You've also filed a motion for individual voir dire and sequestration during voir dire. I'm probably going to schedule another day before trial to sit down and work through everybody or all of the jury selection issues, panel issues, and everything else that may come up.
I think that makes sense, Your Honor. The omnibus motion actually doesn't contain that. That's actually a separate motion. I'm just saying that I didn't plan to address the motions that weren't in there, but I'll certainly do my best. But I agree that the jury-related motions are going to have to be addressed.
And again, I'm just walking through this so we can start creating a record on it. And as far as the special juror questionnaire, I will tell everybody now, so we're as far in advance as possible. What I'm inclined to do in this case is have the parties submit their general voir dire questions to the court so the court can take care of general voir dire through questions that have been submitted, allowing the parties then to follow up with individual voir dire. That's how I think the cleanest way to do this. So I'm just telling you earlier since it was in a motion that was filed.
May I inquire, Your Honor, is this how the court handles it regularly, that the court proposes the general questions to the...
So that's an interesting question. In the 9 years or so I've been doing this, no. But with COVID up in Chatham County, another judge and I have been alternating weeks with what we call Major Crimes Division. That judge has been using a general questionnaire that has been submitted by the parties and has been quite effective. I have not used it, but I think in this case, a lot of the reasons why it is being used up there also come into play. It helps get everybody on the same page with what's going to be asked. It keeps the process itself on track. It keeps everybody moving. It doesn't get them bogged down.
Those are all things that are helpful to the defense when they slow down and we get to actually dive into the thoughts and minds of the
Well, there's
jurors.
also, that's why there's individual one.
Right.
I'm not suggesting that the council doesn't have an opportunity to follow back up. As far as the general questions,
Okay.
everyone uses very similar general questions, it seems. And so, again, I'm inclined just on the general questions, just have the parties submit what they plan to use. If ultimately I look at it, and I see what everyone is thinking about doing, and I'm okay having the parties do it, so be it. But if it looks overwhelming, we may narrow it down and put out general questions from the court together.
Okay, thank you, Judge.
Your Honor, I have to say it's kind of a unique position here. Given the court's desire to ask general questions, it would seem to me that there's no harm in essentially asking as many of those general questions as possible well in advance of the actual trial and getting the responses of the jurors well in advance so that the parties have the benefit of that before we actually bring them in and sit them down in panels. I think once the court says that the court wants the parties to submit the questions in advance and the court to digest them and decide what to submit to the jury, all of those questions could and probably should then be asked in advance by way of questionnaire from the court. I mean, it just seems to me that if the court's going to take the trouble to sit down and decide which general questions are going to be asked, that there would be no reason not to get those answers from the jurors as early as possible.
Just giving everybody an idea on where we're going with things based on what's been filed before the court. As far as the omnibus motion, anything else within the omnibus motion that needs to be addressed, Mr. Bell?
But, Your Honor, I don't think so. At some point in the next 5 months, I think co-counsel will probably be driving up to the GBI crime lab or to the Gwinn County Police Department to physically examine some of the evidence in the case. I don't think there's any reason to further address that today. I just customarily put that in my motion. But I don't think there's anything to do right now.
All right, Mr. Goff, you filed the first plea and bar and the speedy trial motion.
Yes, Your Honor.
Still before the court?
Yes. All right, I don't switch folders here. I don't see this taking very long. I don't wish to make an opening statement unless the state feels compelled to do that. Then we can just move into the presentation of evidence. Your Honor, at this time, I would incorporate, for the purposes of this record, exhibits 1, 2, 3, and 4 from the motion to disqualify. And also the bond hearing transcript with respect to the issue of prejudice in this case. There were some other prejudice references in the motions that were subsequent bond motions that the court hasn't heard with respect to Mr. Bryan's health condition, but I don't think at this point they're going to be dispositive on that. I don't know how to present it, Your Honor, other than to simply say that we believe the court should take judicial notice of a comparable case in many ways to the one before the court, that being the George Floyd case. Mr. Floyd died on May 25th, 2020, according to news reports, and according to other news reports, the verdict was reached in that case on April 21st of 2021. In terms of the ability to get a case tried in a COVID environment, another case, arguably much more complicated than this one, occurred after this crime took place and the jury gone verdict. Beyond that, Your Honor, we would rely on the evidence of record, and matters of record, and particularly the leaves of absence, many leaves of absence filed by the state prosecutors in this case, and also make reference to my motion, my standing objection to leaves of absence in this case. And beyond that, I think the state has marked the emergency judicial, I could be wrong, but I think the state has marked the emergency judicial order and the 13 extensions. And I believe they're going to tender those as evidence on this motion. And if they're going to tender them, then I'm not going to worry about asking the court to take judicial notice of them. The court will have them in front of Your Honor. Beyond that, no, I think that pretty much covers it, Your Honor. That's the evidence that we would like to present. We'd like to make some brief argument after the state has presented their evidence.
And just to be clear, and these may be a little bit muddled. We've got the plea in bar, which is a speedy trial violation, and you also got the motion to declare unconstitutional the indefinite suspension of criminal jury trials.
Well, Your Honor, I think that motion is moot, as the jury trials are no longer indefinitely suspended.
Just want to make sure we're clear about what we're talking about.
Yes, Your Honor.
All right, so, that's it.
Thank you, Your Honor. So, Your Honor, what the state is going to do at this point in time is tender into evidence, and I've done it electronically for convenience of our court reporter. Following documents, which are listed here, and this is states number 8 through 29, and for the record, what we have is States Exhibit 8 is the judicial emergency order dated March 14th, 2020. We then have each subsequent order, which goes in order of the dates. We have our April 6, 2020, as States Exhibit number 9. Number 10 is the judicial emergency order of May 11th, 2020. States Exhibit 11 is the judicial emergency order of June 12th, 2020. States Exhibit 12 is the judicial emergency order of July 10th, 2020. States Exhibit 13 is the judicial emergency order of August 11th of 2020. States Exhibit 14, the judicial emergency order of September 10th, 2020. States Exhibit 15, the judicial emergency order of October 10th, 2020. States 16, the judicial emergency order of November 9th, 2020. States Exhibit 17 is the judicial emergency order of December 9th, 2020. We then have States Exhibit 18, which is the modified judicial emergency order of December 9th, 2020. That was the result of the COVID pandemic getting even worse. We then have States Exhibit 19, which is the judicial emergency order of January 8th of 2021. States Exhibit 20, the judicial emergency order of February 7th, 2021. States Exhibit 21, the judicial emergency order of March 9th of 2021. States Exhibit 22, the judicial emergency order of April 8th, 2021. And finally, States Exhibit 23, the judicial emergency order of May 9th, 2021. States Exhibit 24 is Governor Kemp's executive order dated July 31st, 2020. We then have States Exhibit 25, which is guidance on grand juries. States Exhibit 26, the Supreme Court's further guidance on grand juries, which was then issued on May 11th, 2020. The Georgia Supreme Court's guidance on tolling the statute of limitations is States Exhibit number 27. States Exhibit 28 is the continued guidance on the tolling of terms of court. And then we have States Exhibit number 29, which is Georgia's reopening guide for the court system. And those we would all tender as it relates to this particular motion.
We're addressing 8 through 29, because 1 to 7 do not relate to this motion. We're doing 8 through 29.
Correct, 8 through number 29.
Your Honor, we're not contesting pursuant to the scheduling order of the court. We're not contesting the authenticity of those documents, but we are contesting the validity of all of the extensions of the original judicial emergency. That's argument. That's not evidence. I just want to make it clear, we're not conceding that these documents are relevant to anything. And we're not conceding the substantive truth of any allegations set forth therein. There's a legal argument to be made, but it's not really a factual argument.
There it is.
Thank you, Your Honor. In addition, so Your Honor, now we have State's Exhibit 31, 32, and 33 that I've shown to opposing counsel, and these have all been taken from this morning, and they relate to the Georgia overall COVID-19 status and statistics for the state of Georgia. These are all printed off from the Department of Public Health, the Georgia official website, and I've listed the website down here. They are screenshots from this morning as it relates to May 11th, 2021, as to the state of the deaths, the COVID cases, and overall statistics for the pandemic emergency. At this time, I would tender 31, 32, and 33 into evidence.
Once again, Your Honor, we're not contesting the authenticity. There's no doubt that this is the information that is on the public health website. I think we track the same documents. However, Your Honor, this is all hearsay. It is all a confrontation clause violation. If the state wants to actually prove that there is in fact a public health pandemic, then that's fine. But they're going to need to present expert testimony and other actual evidence. We are not stipulating that there is any public health emergency here, or that it's impacted should have impacted the trial of this case. And I don't mean anybody in disrespect in saying that. We're not conceding that. And we believe that if the state wants to have a hearing on it, that's fine. I would also point out that these documents are irrelevant because there is one local order, to my knowledge, under state law for 1 day that proceedings in this courthouse were closed. We'll give the state 1 day based on the local order. Beyond that, it's irrelevant because the only thing that matters is whether the orders entered by the Georgia Supreme Court and the actions taken by the governor are valid as a matter of law. So,
because I don't think this happened, but I just want to make sure we're clear the record. Those emergency orders weren't challenged under the statute, were they?
I'm sorry.
Those emergency orders were not challenged under the statute, correct?
Challenged by who?
By you, by your client. Because
Your Honor,
there is a process that exists in the statute that permits the emergency orders to be issued where they can be appealed. And it's not to the Superior Court.
yes, Your Honor.
So my understanding is this is the only place where this is being litigated, is here in Superior Court.
We're not litigating this anywhere else, but our position is that if we're going to litigate,
And let me be clear. Litigating the validity of the emergency orders. So is that what you plan to do here?
yes, sir. We may not get very far. That's what we plan to do.
Diminish.
thank you, Judge. So for the record, State's Exhibit number 31 has Georgia overall COVID-19, the status. Confirmed cases in the state of Georgia, 887,443. Confirmed deaths, 17,722. Hospitalizations due to the COVID virus, 62,324 in the state of Georgia. As of May 11th of 2021, the number of cases of COVID in the last 2 weeks in the state of Georgia were 11,017. As of May 11th, 2021, the total number of deaths per 1,000 people, meaning the ratio is 163.6, meaning the total deaths in the state of Georgia since the pandemic, once again, was 17,722. For the population of the state of Georgia at this time, listed at 10,833 people well, 10,833,472 people. Thank you, Your Honor.
I understand it's all the evidence the state intends to rely upon.
Yes, that's all the state's evidence.
Any argument from the judge?
Yes, Your Honor. Your Honor, I don't think there's any question that the length of delay at this point, there is a presumption of prejudice that arises. If the state wants to argue the difference between May 13th and May 21st, we can certainly come back next week and take it up at that time. But seeing as we know that we're not going to try this case before the 12 months has expired, we believe the motion is right. Of course, there is some legal authority that it was right at 8 months, which is why we filed it when we did. Your Honor, the delay in this case is not attributable to the COVID epidemic. This court, of course, has made no factual findings prior to today, and the court has admitted these printouts from the Georgia Department of Public Health. I'm not sure what purpose the court has admitted them for, but they are here. They're subjects of expert testimony, and you can't simply print out a website and substitute that for evidence. So I'm not sure what the purpose of it was. The court will address that. As far as our position is, the state of Georgia has presented no evidence in support of the so-called public health emergency in this hearing. That evidence has no probative value. Your Honor, furthermore, there's been no order entered by this court up to now. The state is traveling, notwithstanding the presentation of that evidence, they're traveling under the emergency judicial orders in this case. And there's certainly nothing else of record. The problem, Your Honor, is that the first emergency judicial order, and I do want to make sure I get all this right, the first order that was entered references the governor's declaration of the state of emergency pursuant to 38-3-51. Subsequent orders entered by the Georgia Supreme Court neither invoke the governor's declaration nor make any independent factual findings to support the Supreme Court of Georgia acting on its own authority. None of the extensions were valid, and having made no factual findings of its own, there wouldn't be anything for us to appeal anyway. The problem is, beyond that without a declaration, the Supreme Court's authority is limited to 90 days. But in this situation, even if you ignore the fact that the Supreme Court did not cite the governor's declaration of the state of emergency, the governor's declaration of the state of emergency itself is only valid for 30 days. Beyond that, the governor has to get the concurrence for these extensions, requires the concurrence of the legislature. And any other reading of these statutes is going to be an unconstitutional delegation of power. The governor can't declare extensions for an indefinite period of time based on the concurrence of the legislature originally. So there is no valid governor order, and that beyond the 30 days, the Supreme Court can't go beyond 90 days on its own. And therefore, in ruling on this motion, the court can't rely on anything beyond the initial declaration of emergency judicial order by the Georgia Supreme Court. Now, I wish the court well in discerning through all that, but I think it's pretty clear. I have to say, I don't think there are any cases on this subject. We haven't had a public health pandemic in 100 years. But beyond that, moving to the other issues in the case, Your Honor, we contend that the delay in this case was intentional, and that is manifested in the record, rather than due to neglect or inadvertence or the public health emergency. We contend that the delays in this case have been, at least in part, for political gain. We can't help but notice, and the matters of record in the case will show, that this case was rushed within days. I can't remember if it was 1 day or 2 days within which the McMichaels were arrested from the GBI's entrance into this case. And Mr. Bryan's followed, I think, 2 weeks thereafter, or a week thereafter. Those are matters of record. Furthermore, the state rushed this case to indictment to appease the woke left mob, which seems to be gaining ever-growing influence in this country. The transcript that was submitted with regard to the motion to disqualify, which is quoted in the disqualification motion, makes it very clear that the state rushed this case into the grand jury ahead of all its other murder cases in Cobb County, basically because of threats of violence and rioting around the country. So the state clearly has the ability to move this case when it wishes to. On the other hand, the discovery process is still underway. Discovery continues to come forward, hence the motion on file, which I suppose we'll address another day about yielding the lily here. The fact is that most of the investigation of this case took place in the pandemic, and most of it took place up front. Now, there's been other things that were done, but the vast majority of the work in this case was done up front and very quickly. As referenced in the motion to disqualify, we contend that the state of Georgia, that the Cobb County District Attorney's Office, has used this case as a campaign prop. The longer this case goes on, the more opportunities to have press conferences and make statements to the public about it. And I'm not saying that they don't have the right to do that, but they don't get to have their cake and eat it too. And they can't delay this case for reasons that have nothing to do with the merits of this case or the need to get it done for other purposes, and then come in and claim that Mr. Bryan's speedy trial rights are not being violated. Your Honor, the leaves of absence that were filed in this case by the state of Georgia from the outset, cumulatively, are absurd. I don't think that I have filed a single leave of absence in this case. I think maybe the McMichael lawyers filed one. I think somebody has a wedding maybe later this week. The state, through multiple lawyers, files leaves well over the 30 days that are provided by law. We filed a standing objection, but apparently that's not. I guess we'll get to that objection at some point. And I'm not suggesting that any of these leaves of absence are in any way the court's fault. The lawyers file them. I get that. But the bottom line is, most of the last year, it seems like one person's leave or another in the district attorney's office has prevented this case from being tried. You can't blame COVID-19. Even if the court decides that the state can simply print out from a website as a substitute for actual expert testimony, putting that issue aside, the state can't blame COVID-19 for the delays in the trial of this case, because the state has never announced to the court, nor to the counsel in this case, that they're ready for trial. As we stand here today, they're not ready for trial. So how can you blame a suspension of jury trials for the delay in the trial of this case when the case has never been ready for trial? Now, you could claim in a lot of cases that maybe COVID has had some impact on the investigation or delayed the investigation of this case. The evidence is closed, subject to motion to reopen. The state has not argued that COVID had any impact on the investigation of this case. They haven't. And even if they did, as I said before, most of the investigation in this case, most of the groundwork was done early. So then you have the fact that because jury trials have been suspended, all these expert witnesses, the crime lab, all these other people, they haven't lost any time for trial. Normally, experts and key investigators are tied up under witness subpoenas around the state at any given time. That hasn't been the case here. So if anything, COVID has made it easier to investigate and get this case ready for trial, and not harder. Last issue, Your Honor, is prejudice. As Your Honor will undoubtedly recall from the bond hearing, in fact, I think the court referenced some of these prejudice issues in the entry of its order denying bond for Mr. Bryan. As a result of his arrest, Mr. Bryan has lost his home, a factor which has been used by the state to deny Mr. Bryan a bond, because suddenly he's a flight risk, because he didn't spend his life living in this community because he lost his house because of the government's action. He's lost his car. He's lost his job. He's been separated from his family, from his friends, and his fiancée. And we can argue as to whether there's sufficient record or not as to his health issues, but certainly it hasn't been good for his health. In fact, we've notified the sheriff's office as Mr. Bryan sits here due to his high blood pressure. As he sits here for an hour or two, his legs are swelling and his circulation is being cut off because the restraints that were totally appropriate when applied earlier in the morning and earlier in the afternoon are now too tight. There's manifest prejudice to Mr. Bryan, and we think under the facts as presented that this case is due to be dismissed as to Mr. Bryan.
Thank you, Judge. Your Honor, a constitutional speedy starts to run from the date of arrest, and so therefore indicting quickly or slowly has nothing to do with the length of time to be considered. In addition, Mr. Bryan filed a speedy trial demand prior to indictment, seeking to get this case moving as quickly as possible. He now turns around and complains of that. So first off, Your Honor, we're talking about the Barker v. Wingo factors. That's 407 U.S. 514, the 1972 case. First, to trigger a speedy trial analysis, an accused must allege that the interval between the accusation and trial has crossed the threshold dividing ordinary from presumptively prejudicial delay. This is a 3 co-defendant homicide case that was extensively investigated by the Georgia Bureau of Investigation. The pace that we have been moving at is the standard pace for such a case. By definition, a defendant cannot complain that the government has denied him a speedy trial if it has, in fact, prosecuted his case with customary promptness. Forget the pandemic for a moment. We have moved this case with customary promptness. We have had the preliminary hearing, the bond hearings. This court set scheduling orders. Motions were filed December 30th, January 30th, and we now have this motions hearing date here in May, and we have a trial date for October 18th. This is moving with customary promptness. However, taking COVID into account and looking at the other homicide cases out there, every single case has been delayed. We were not having trials in court up until very recently. So these defendants are in no different position than anyone else in the state of Georgia who has been indicted and charged with murder. But the Barker v. Wingo factors are the most important thing to look at. First off, the length of the delay. Yes, we are approaching a year. The reason for the delay. There is no reason for the delay. This has been moving with customary promptness. The defendant's assertion of his right, yes, he asserted right away, even before it was indicted. He has now filed this motion 8 months in, when he should have. The main factor is the prejudice to the defendant. First, oppressive pretrial incarceration. Yes, he has been locked up this entire time in the jail. Anxiety and concern of the accused. However, anyone who's incarcerated pending their murder trial is going to have anxiety and concern. The real factor in a Barker v. Wingo analysis is the possibility that the accused's defense will be impaired by dimming memories or loss of exculpatory evidence. And, Your Honor, here the defense has provided absolutely no evidence of that. What the defense has said is that the prejudice involved is the loss of a home, car, job, friends, family, fiancé, health. None of those qualify under Barker v. Wingo. The possibility that the accused defense will be impaired by dimming memories and loss of exculpatory evidence. The balancing test that's required by the court, the state requests that the court not hold it against the state or the defense for the delay of a year, as this has been moving with customary promptness. The reason for the delay is customary promptness. We have been moving this very expeditiously, so that factor should not be carried against either party, especially under the circumstances of COVID. The defendant asserted his right. That goes towards him. However, he has failed on the prejudice to the defendant prong, especially on the most important prong, which is that his defense has been impaired. He's presented absolutely no evidence that his defense has been impaired, and therefore we ask that you deny his plea and bar on constitutional speedy trial grounds. Thank you.
Final word, Mr. Gall.
Your Honor, obviously the most important kind of prejudice in case is where the defendant cannot have a fair trial because evidence has been lost or witnesses' memories have faded. And that's certainly true, but it's not the only source of prejudice. The mere fact that he's been incarcerated itself is prejudice and the attendant results of that. And for anybody who's been incarcerated over the past year with COVID and this constant fear of being locked like a rat in a cage and unable to do anything to protect yourself, although credit to the sheriff's office, which has done a magnificent job of protecting our inmates. But still, that is a traumatic experience unique in this circumstance. But to say that this motion isn't valid because we haven't proved that witnesses' memories have faded or evidence has been lost. Let's be clear. We're way away from trial, and we're going to find out as we get closer to trial how much evidence has been lost or destroyed. Certainly when we go to the crime lab, we can only hope that everything has been preserved. We already have one witness whose deposition I thought we were taking a long time ago, but apparently whatever arrangements the state has made with the English family and the McMichael lawyers, I don't know what they are, but heaven forbid he should pass away before we get this case tried. These kinds of prejudicial matters normally don't show up this early. So it may be that that's an issue that gets left. And it's also entirely possible that sometime between now and October we'll be back with a second plea in bar if further evidence of prejudice develops. I disagree with the state in characterizing that the delay in this case isn't uncommonly long because this is the way they do things. First of all, I haven't consented to the prosecution stating anything in its place. Really, I kind of expected the prosecution to put up evidence if they wanted to establish this was the customary way things are done. I know that the only other dealings I've had with Cobb County were in the DeMarquise Elkins case. And that case got tried 13 months, if I recall, from the day of the death. In this judicial circuit, on a case of this importance, this case has already been sitting too long. I can't speak to what they did in Cobb County. But this idea that they just get to come in and say, oh, Judge, this is the way we do things, and that bald representation to the court in a closing statement is somehow evidence that the court couldn't in any way consider. The burden of the state here is to show that. If the state had any reasons why this part of the investigation, that part of the investigation required time, they had the opportunity today to present that to the court. And shockingly, they chose not to do that. And I think the court can presume from the fact that they didn't present any such evidence, that there is no such evidence, and that there is no legitimate reason why we haven't, this case is not in a posture to try today. And I can't tell anybody else how to do their business. But simply coming in a closing statement and saying this is the way we do things, that is just facially insufficient. Under the presentation of evidence or the lack thereof by the state in this case, I respectfully submit that it would be an abuse of discretion not to grant Mr. Bryan, and I mean that with all respect, not to grant Mr. Bryan his dismissal with prejudice in this case. In the alternative, knowing that we have another 5 months before this case will go to trial, at a minimum, the court might also consider in the alternative finally granting Mr. Bryan the bond that we've been requesting for a year now through 3 motions, 4 motions, I've lost track. We'll probably file another one soon enough. If the court wants to address the prejudice to Mr. Bryan without dismissing this case, the court always has the option of releasing him on bond. Now, what happens in federal court with that? I have no idea. I don't represent Mr. Bryan in federal court. My job is to represent him here. And I know that if the court grants him a bond on the state charges, he and his federal counsel will have to deal with federal court. So I can only do what I can do. And, Your Honor, that is my argument.
All right, he's right. As I have listed remaining, I have the motion to exclude from trial all jail calls. I've got a Gabriel motion. I've got a Brady motion. There's this Jackson-Deno issue that was suggested can be addressed tomorrow if we're in a one-witness posture on that. And then finalizing this discussion about what we do with the 401, the relevance and the mental health of the defendant. That's what I have on my list. And I bring that up because it is 5:40. And we have a full day tomorrow scheduled. It strikes me that we can handle all of that in the time allotted tomorrow. With that being the plan at this point, anything from the state on that or any matters that we have addressed today?
No, Your Honor, we will have Special Agent Seacrest here tomorrow for the Jackson-Deno here.
Right. And Travis McMichael.
Yes, Your Honor. we will be prepared to talk with the court about the mental illness issue. Depending on how the court rules, we may be asking to make that proffer still, to put it on the record, acknowledging the court's concerns, but we want to be able to fulfill the purpose of this hearing and make a very clear record about it. So that will take a little bit of time with the court's permission. Just want to make the court aware of it.
Again, we're gonna.
Yes, sir.
Of course, gonna work through that this evening.
Yes, sir.
Right on to it. From Gregory McMichael.
We'll be ready, Your Honor.
From Mr. Bryan.
We'll be ready, Your Honor.
All right, thank everybody for their time. We are in recess until 10 o'clock tomorrow morning.
All right.
Yeah, we will take that.
Make sure I have all the exhibits, please. Before we all leave.
Smooth as massive. Yeah, he's great. He's awesome. He's working.